The adoption of the new data privacy framework was rendered possible by the fact that the US president adopted a new executive order reforming the activities of US surveillance agencies. Under the new executive order, there is a new court that is in charge of examining the claims that could be brought before it by US or EU citizens complaining about the ways our data are collected and processed by US intelligence agencies. Of course, the guarantees that are provided under the new framework are currently contested by some stakeholders, as Maximilian Schrems, for example. Some people say that it's not easy to bring a claim before the new court, and some people highlight the fact that Section 702 of the Foreign Intelligence Surveillance Act has not been changed. As previously said, Section 702 allows the NSA to be granted an authorization on an annual basis for surveillance programs that are not specifically targeted. In other words, it is for the NSA to determine itself the targets of those surveillance programs, and there is no oversight in the designation of these targets. Some people say, given the fact that Section 702 was not modified or reformed, the new data privacy framework will certainly be invalidated as the safe harbor and the privacy shield were invalidated. More specifically, Section 702 was supposed to expire at the end of 2023, but it has just been renewed by Congress for another 4 months until April 2024, so that Congress can decide what to do with Section 702, if this section should be just renewed in the exact same terms, or if it should be reformed. And it is, of course, a topic of major importance, because if the European Court of Justice has to decide whether the new data privacy framework is compatible with GDPR, it will take into consideration the state and the wording of Section 702, and whether this Section 702 was renewed with no modification or not. So this is currently a situation of great uncertainty, because currently companies willing to transfer data from the EU to the US do not know if they can rely on the new framework that could be invalidated, and do not know if they can really rely on standard contractual clauses, since a few companies have been sanctioned for doing so. Last option would be for them to just store the data in the EU and stop transferring the data to the US, which is a solution that is advocated by many stakeholders here in Europe. And some people even say that the data should be stored in the EU by European companies that are not subject to US legislation. This is the idea of the so-called sovereign cloud. And of course, this implies that European companies and French companies are capable to offer cloud services that present the same cybersecurity guarantees than the current American companies that are leading the cloud market, such as AWS or Microsoft. Sciences Po.